world is changing, and so does change. But the mind has the potential to capture the changing world and make every change count. At SkillsMindset, the leading global skills, strategy and corporate development company, we believe that the mind has the potential of transforming the man from obscurity to prominence. It's the reason why we make skills our business. At SkillsMindset, we stand for change, for development and for success. We challenge, we inspire and we lead. With SkillsMindset, your limit is just the beginning. Welcome to SkillsMindset. For more information about the great service we provide, please visit our website on www.skillsmindset.com or give us a call on our UK number on 07957 676 193. Better still, send us an email on info@skillsmindset.com. Skills Mindset. Challenging limits, maximizing opportunities.
Greetings to everyone. We are honored to welcome our distinguished guest speakers, valued viewers, and all participants joining us today. This masterclass marks the beginning of an enriching learning journey that we started this year, focused on developing practical skills, cultivating transformative mindsets, and achieving meaningful impact. So thank you for being part of this May 2026 edition. We look forward to insightful discussions, engaging conversations, and of course, outcomes that translate into real-world growth. So welcome. Let us begin. Whether you are joining us live or watching the replay, we are excited to have you with us for another transformative session. So let us know where you are joining or tuning in from, including the city and country. So let us know, drop in the chat, also in the comments, where you are joining from. You can mention your name, the city, and of course, the country you are joining from. So we would like to acknowledge you. We would like to recognize you for being part of this incredible and transformative masterclass. The session that we're going to go into in a short while, and of course, we're all going to participate. And feel free to always put in your comments, your observations, your opinion, your remarks, and of course, your questions. We have our experts in the house that will be able to, and willing as well, to address all your concerns. So welcome to another edition of the Power Mind Skills Mindset Masterclass, guided by an experienced expert. This is a fantastic opportunity for skills development, business advancement, professional growth, and leadership. But tonight, this session is one that every individual, every parent, every entrepreneur, and every family absolutely needs to hear. Our topic tonight is securing your tomorrow today. Essential planning every family should have before it is too late. Wonderful question, wonderful topic, very interesting. Now, many people you will know spend years building income, building businesses and building careers. We're still doing that, and building dreams. But very few take the time to build protection around those things that they have built. And the truth is, life is unpredictable. The greatest gift we can give to our loved ones is not only success, or why we are here, but security, clarity, and peace of mind for the future. This session will uncover critical conversations around planning, protection, legacy, financial preparedness, and of course, the practical steps family and business owners must begin to think about and take action today, not someday. So because waiting until later often becomes too late. As that is why this masterclass is so important. So please, you are free to invite friends, send the link to your colleagues, to your family members, to your children, to your parents, to your business partners, to your, to your neighbors if you care, and to your followers. This is going to be interesting and exciting. We're especially honored tonight because this is the very first time our guest speakers will be joining the SkillsMindset Masterclass platform. And trust me, you are in for something transformational. Our guest speakers are Chris and Sarah White. And they are prepared to share profound, practical, and life-changing insights that can help families become more secure, businesses become more prepared, and individuals become more intentional about the future they are creating. Tonight is not just another masterclass. It is about wisdom. It is about responsibility. It is about protecting what matters most. So wherever you are joining from, I encourage you, get your notebook ready, get your questions ready, stay fully engaged, remove distractions, and invite others to this conversation because the information shared tonight could truly change and transform lives for generations. We're privileged to welcome an accomplished professional who work in helping families across the United Kingdom secure their future with clarity, confidence, and of course, with peace of mind. I'm introducing Chris at the moment. Chris White is the director and head of estate planning at Trinity Life Limited, a respected estate planning firm serving families throughout Wales and England with extensive expertise in wills, trust, lasting power of attorney, estate preservation, and family wealth protection strategies. Chris is passionate about helping individuals and families safeguarding and what matters to them. Over the years, he has guided countless families through the often overlooked but critically important process of protecting their families, their homes, their assets, their loved ones, and legacy for the future generation. His work goes beyond legal documentation. It is about ensuring that families are prepared, protected, and empowered to make informed decisions before life unexpected moments arise. Chris is especially known for his practical, compassionate, and straightforward approach to estate planning, helping people understand complex matters in a way that is both accessible and actionable. And I've got my experience about that. His mission, though, is to ensure that every family has the structures in place to protect their wishes, preserve generational wealth, reduce unnecessary stress for loved ones, and create long-term security. While we are settling in, I'm going to ask our guests. Now, let me just say to you, Chris and Sarah are here, which is we're getting double for what we
yes, double trouble.
We're getting double for what we bargained for. While we graciously accepted, extended the invitation to Chris to, be the lead speaker today or the guest speaker today. He graciously brought another wonderful, fantastic professional, even in this area and this field for years along with him. And he's going to be the lead speaker. And I bet you the both of them will be talking about the same thing. And it's going to be, interesting. But while we settle in, I'm going to allow them, Chris and Sarah, to briefly share a bit more about themselves, their current works, and of course, their expertise before we go into the meeting. So while people are settling in, we have guests watching, people watching from Facebook, people on LinkedIn, and we have some, in fact, a lot of them on YouTube. So please keep telling us where you're joining from. Let us know where you're joining from. We'll be glad. We have Sunday already. We have blessings. So if you want blessings, Facebook, Sunday from YouTube, and there are many like that. LinkedIn also is here. So it's a great privilege to have the two of you together. Chris or Sarah, maybe I should mention Sarah first now. You want to tell us a bit more about yourself, just in a little. This is just for people to settle in. Tell us what you're all about, what you're doing presently, and why are you doing?
Yeah. So do you want to start?
Yes. Hi everyone. So we've been Trinity Life now has been going probably about 5-6 years, and we've built it, and speaking to more. We're happy to reach out to churches now. We're building our relationships with churches, which is amazing. Christians coming to us now for wills. We're getting the opportunity to do this kind of talks now as well, which is excellent. So we've been doing estate planning now. So that's mainly wills, trusts, and lasting powers of attorney that we do concentrate on. We obviously do other things like life insurance, lifetime planning, inheritance tax planning through our third-party IFA and partner company. So we've got a full suite really for the whole estate planning section. So
Yeah, absolutely. It's God's given us more and more opportunities because we are Christians. I'm not sure if all of our viewers are Christians, but we're Christians. We speak to Christian people in Wales and England because that's the areas we cover. We do events like this more and more now, and speaking like I done a lunch the other day or a brunch, and then we speak in settings like this. And on a daily basis, we have appointments with people, and we help them plan their future basically, and make sure that they leave an inheritance to their children's children, which is a biblical principle that we founded the company on. We specialize, as Sarah said, in wills, trusts, and lasting power of attorney. And normally people are quite shocked at the things they didn't realize. So we're going to talk more about that tonight, and it's almost guaranteed that people are going to be shocked with some of the stuff we'll be sharing, because if they knew, they wouldn't be in the position they were in. They'd already have these documents in place.
Yeah, thank you. Lovely. Yes, people are actually expectant. The people have said, pleased to be here, journey from the UK. That's Blessing saying that. Sunday from YouTube saying, great to be here to learn. So we need to learn. And Anthony from YouTube also saying that looking forward to insight on securing one's estate for posterity. All right. So people are happy, showing their smiling emoji as well. So and I promise you that you won't be disappointed, but get your pen and paper ready. You will need it, and you will have questions to ask. I can tell you that also. All right, so lovely. Let's do this. So, tonight's masterclass titled Securing Your Tomorrow Today, Essential Planning Every Family Should Have Before It's Too Late. Tonight, I believe it will provide valuable insight into wills, into trust, into lasting power of attorney, protecting the family, home, and ensuring that personal wishes are carried out properly for the next generation. This is more than a conversation about, about paperwork. It is a conversation about responsibility, about legacy, about protection, and peace of mind. Please join me in giving a very warm Skills Mindset Masterclass welcome to Chris, Christopher, and Sarah White. Over to you, your presentations.
Yes, thank you, Gbenga. Thank you for the introduction. And yeah, you used the word responsibility, which you used that a couple of times, and that's a very important word because a lot of people, they don't realize how much responsibility they actually carry in these documents and having these documents in place. And when we tell people, they're shocked that they never realized the position they put themselves in or potential position they could have put their family in, not knowing that it was their responsibility to get these documents in place. But a lot of people put it off because they don't like talking about losing capacity. They don't like talking about, passing away. They think maybe if they talk about it, it's going to happen or something like that. But it's going to happen anyway, whether you talk about it or not. We're all going to die, guaranteed. Yeah. So these are important conversations. And what we always say is having difficult conversations helps protect your family from difficult situations. So you've got to weigh up which one you want. If you have the difficult conversations, they don't have to go through the difficult situations. So that's what we like to do, is have them difficult conversations and hopefully make them not so difficult and explain it in a way where you can understand it and you can benefit from it and you can learn and you can protect your family and put these documents in place. Yeah. So we've got the slides there. So security or tomorrow today, essential planning every family should have before it's too late. So we go to the next slide, sir. Okay, so estate planning is quite a broad term, but a lot of people haven't heard of it. They just think will. Most people that we speak to know exactly about a will, and they all realize that having a will is very important. And they come to us and they say, oh, we just want a will. And then when we try to tell them about all these other things, their jaw's almost hitting the floor because they're like, wow, I just thought it was a will. But they enter into the area of estate planning and a whole new world opens up to them they didn't even realize existed. And in that world, there's things that they're taking risks upon which they didn't even know about. So that's the first thing. Is estate planning isn't just a will. That's the starting point. But there's many other things as well, like trusts, power of attorneys, guardianship, all that kind of stuff. Yeah. So
yeah. So most people spend years building wealth, but with very little time protecting it. So it's true, isn't it? You're busy building your business, working on your business, trying to build money, investments. But it's important now to spend some time planning what's gonna happen to all this. If you weren't here tomorrow, what's gonna happen?
Yes.
So and obviously when you've done that, that creates a peace of mind, and then it also protects the people that you love, because that's your decision. That's what you wanted to happen. Doesn't leave anyone not knowing all what would they have wanted. So without the planning there, you'd have delays, disputes, which we see all the time. People not knowing what was the right wish. If you've got the will, that was their wishes when they set that will up. Frozen assets as well, which Chris will talk about now with the power of attorney, and unnecessary tax as well. So there are tax advantages as well with the estate planning.
Absolutely. Okay, so we'll start off then with wills, because that's what everybody comes to us for, because that's all they think they actually need. So either they've got a very old will and they want to update it, or they've got no will at all. Now, what I always say is that basically, without a will, intestacy rules apply. So if you pass away, the government basically decide who gets what. Now, they've got a criteria they've got to follow, but obviously it can take a long time, and they will essentially be deciding who gets what, which nobody really wants. You want to make sure the people that you want to inherit actually inherit, but without the will, you leave that to chance. You leave that in the hands of the government, and obviously they don't care as much as you about the right people getting your inheritance. Yeah. So that's the first thing. Having a will stops the rules of intestacy applying. And then it's a different thing then called probate instead of intestacy, which is far easier and far better in terms of who actually gets what, because it goes to the right people. Yeah. And as we can say, the number two, family disputes can arise because if you've fallen out with one of your children, or maybe you wanted to exclude a family member and you don't have a will, the rules of intestacy might give the assets, will give the assets to your bloodline. and you may not want that. So that's where you have to have a will to make sure that doesn't happen. Yeah. But I think for me, the main reason I did a will is because we've got 3 children. My eldest daughter's just turned 18, but up until the other day, we had 3 children under 18. So we wanted to make sure that we put guardians in the will, so that if something happened to us both before the children turn 18, God forbid, then my mother is the guardian, and she looks after our children anyway, because me and my wife work in this business. So my mother is our nanny. She's done it since my first daughter was born 18 years ago. So that she was the natural person that I would want my children to go to. And we know that if something happens to us, that is exactly what will happen, because we've written a will and we've named my mother as the guardian. And I can't tell you the peace of mind that gives us, because I don't have to worry. You know, worst case, God forbid, something happens, my children are going to be looked after. They're going to be loved. You know, we couldn't think of a better situation if we weren't around. But if we hadn't done a will, they may not give them to my mother. Plus they might even go into care for a period of time. Social services will then decide who's going to look after my children. You know, they might give them to a different family member that we wouldn't have wanted. So we've stopped that from happening by doing a will, and we encourage everyone, if you have young children, that's the main reason to do a will at the very least. Yeah. And that's what we're doing now.
That's fine.
Yeah. Okay. Yeah. Okay, so we go to the next thing now. So a power of attorney is an often misunderstood document. So it's different to a will, because a will kicks in when you pass away. But a power of attorney is for whilst you're still alive, but unable to make your own decisions. It's not for when you've passed away. The power of attorney actually dies with you, and the will takes over from the power of attorney. The power of attorney takes over from the
The
will takes over from the power of attorney. Yes, sorry, yes. Yeah. So you have a will when you're gone. You have a power of attorney whilst you're still alive. Yeah. But a lot of people come to us and say, "I want a power of attorney because when I pass away, I want to make sure my family can distribute the assets.
I want to get into the bank account."
Yeah, exactly.
Like, no, it's not for after your days. It's only for while they're still alive.
And we say, "Oh, you must mean an executor. You're talking about an executor of the will. An attorney is a different role. It's for whilst you're still alive, but unable to make your own decisions." Now, according to Martin Lewis, the money saving expert, he says that in his opinion, a power of attorney is more important than a will. Because if you're still alive and you lose capacity, they can freeze your assets, including bank accounts, joint bank accounts, if you have joint bank accounts, properties, pensions, investments, ISAs, everything can be frozen. And then your spouse or your children or your family, whoever wants to help you make decisions and look after you, they would have to make an application to the Court of Protection to become a deputy. And that can take up to 2 years and cost in excess of £8,000. So you would never want that to happen. That's why Martin Lewis says a power of attorney is actually more important than a will. We say they're as important as each other, but power of attorney is definitely a very important document. Yeah.
And again, it says they're important regardless of age. Again, people think it's something to leave until later life. You know, we've done our powers of attorney, we've got each other, I got my sister and brother. So even though the children are under 18, we've done them now for children under 18. Once all of the children are over 18, we'll do them again, because we'll then bring the children on. So it's a lifetime document. We should always have these documents in place.
Definitely. You know, I'm 43, Sarah's 47. We've got no intention of losing capacity. It's not even something we even thought. It's not even on our radar. But if something was to happen, we have mortgages and things. I would leave Sarah then with mortgages which can't be renegotiated. We've recently renegotiated our mortgage on one of the properties that we own. We would, if I'd lost capacity, Sarah wouldn't be able to do that because it's in both our names and both of us have to sign, you see. So I couldn't leave Sarah with bank accounts, mortgages, property. That's why we did our power of attorneys. And like I say, our children are under 18, so we haven't put them on. We put my mother on and my wife's sister and things, so you can still do them even when you're young, and then you do them again in the future when the children turn 18. And you see, now there's one for health and one for finances. So there's 2 types of power of attorney, and if you're a couple, then you have 4 documents in total: 2 health, 2 finances. If you're a single person, you don't have to have both, but we recommend both types. We will always recommend a health and a finances power of attorney, and then nothing gets frozen. Nobody has to go through the courts, and it's just you know,
and decisions in the hospital as well.
Health decisions.
Health decisions could be, you know, if you're on life support,
life-sustaining treatment.
You know, it's so important to have the documents because you just don't know what could happen when. So it's best to be prepared.
Absolutely. If something ever happened to me, obviously Sarah's my attorney on the health document. I know that she will give or refuse life-sustaining treatment, and there's no better person to give it than my wife. I love doctors. I praise God for doctors, but I would much rather my wife make the decision with the doctor's advice, and she makes the final decision. And because we've done our power of attorney, that's exactly what will happen if that ever happened to us. So yeah, very, very important point. Regardless of age, it doesn't matter how old you are. They're not just for old people with dementia and Alzheimer's. It can be an accident. It can be anything could happen to you at any age. It could be anything at all. So a loss of capacity doesn't mean you're old. It just means you lost capacity. Age has got nothing to do with it. Yeah. Okay, so now we go on to the deputyship. As we said, if you don't have a power of attorney and something happens, there's only one option. You, or, you know, like if we didn't have one now and something happened to me, Sarah would have to make an application to the Court of Protection to become a deputy. Even though she's my spouse, she still can't access my finances. Even a joint bank account, which she's named on, can be frozen. Just because she's my spouse and she's named on the account, she can't automatically continue making decisions. So the account can be frozen until a deputyship order is obtained through the Court of Protection. And as we said earlier, that can take up to 2 years in the worst case scenario, and it can cost thousands and thousands of pounds. So that's an option you absolutely want to avoid. As Christians, we call it the road to hell, because it's such a bad option. It may as well not be an option, because in the worst case scenario, and we know we've seen this happen, they can put themselves on as a court official. So if something happened to me now and Sarah went to the Court of Protection, they can deny her access of being a deputy. They can say that she hasn't got experience to be a deputy because she's never been a deputy before, and they can appoint themselves as a court official. So they would be making the decisions, and my wife would have to answer to them and explain the decisions that she's making. She'd have to report back to them because they are the deputy. So nobody would ever want that. That's a farcical situation that you absolutely want to avoid. And if you don't have a power of attorney and you lose capacity, then that is what's going to happen. So we can't stress how important these documents are. Not trying to scare anybody, we're just giving facts here, and we wouldn't be doing our job unless we told you the dangers of not having them. Yeah. So deputy, as we said, court involvement, yes. LPAs allow trusted people to act quickly. So you could put your spouse on, you could put your friend, your parents, you know, whoever you want. It doesn't really matter who the attorneys are, as long as you trust them 100%. Yeah. Because you know it is an important role, so it does matter who they are. But I'm assuming you wouldn't put people on you don't trust anyway. And they will step into your shoes and they will make decisions as if they are you. Nothing gets frozen, and it's a far better option than the deputyship order. Yeah. And planning early creates peace of mind. We can vouch for this. We've got our power of attorneys. They're registered. They're in a brown envelope in one of my trays on my desk. Every day when I'm on Zoom calls, I look over and I say, my power of attorneys are over there. And a sense of peace comes over me. Every time I walk past and I sit on my chair, I see the brown envelope and I say, yeah, I've done my duty. As Gbenga said earlier, I've done my responsibility. I've taken that responsibility because it's my responsibility. It's my wife, it's my children, they're my assets that God has entrusted to me. And that's what we've done, is to take responsibility. So that's good. Okay, now a little bit of a different subject now, and a very common thing that people that don't realize this. I find this one the most shocking of all. A lot of people have got life insurance. Almost every couple or person that we speak to, they've got a mortgage, they've got life insurance of some description. But when you ask them about life insurance being written into trust, they look at you as like, what's that? I mean, I got life insurance, but what's the trust part? And they don't realize that if life insurance isn't written into trust, it pays out into the estate of the deceased person. And the problem then is it's subject to probate, which can take, 18 months in a worst case scenario, sometimes 2 years. Yeah. And if you're waiting to pay a mortgage off with that money, so if I was to pass away and I didn't have my life insurance in trust and my wife wanted to pay the mortgages off, she'd have to wait to go through probate first, which could be a very long time, and she'd have to pay the mortgages on her own without my wage coming in because I've passed away. So she's got one wage now and have to pay all of the mortgages. Maybe she'd be off work as well, looking after the children, grieving. she'd have to wait for that entire probate process, and it could also be subject to 40% inheritance tax because it comes into the estate as an asset, so it adds on to the estate. And nowadays, from April 2027, with pensions coming into the estate for inheritance tax as well, the last thing you want is a life insurance payout being added onto the estate and being subject to 40% inheritance tax. And that is exactly what will happen if you don't have your life insurance written into trust. And an alarming statistic is 88% of people in the UK don't have their life insurance written into trust. So only 12% of people have the life insurance in trust, which is a shocking statistic because it's the no-brainer of all no-brainers. In fact, if you speak to your life insurance company, they encourage you to put it in trust. They even give you the trust forms for free. All they say is, fill the forms in and we'll pay it out into trust. Like, please do it. Every single life insurance provider will do it, but people don't even realize. And the Bible says, my people perish for lack of knowledge. So if you don't know something, you perish in that situation because you didn't have the knowledge to protect yourself. So if you have life insurance, it needs to go into trust. They do tell you to get professional advice when you're doing the trust forms because it can be a little bit complicated and you have to pick what type of trust. So you would want to probably get professional advice. We can help you with that. And we can also review your policy through our partner company, and they can find out if you've got the right policy for the right time and obviously the right price as well. So we can definitely help you with that, but absolutely essential life insurance going into trust. Yeah. Amazing. Now this is one of our favorites. The next one is tenants in common. A lot of people don't know this. A lot of people have got a jointly owned property. So this basically, this part now is for people with jointly owned properties. A lot of people come to us, they have one property, two properties, four properties, whatever it is, but all of them normally are jointly owned. And then we tell them the dangers of a jointly owned property. If you pass away, even without a will, and you own something jointly, it automatically goes to the joint owner. It's called the rule of survivorship. So that doesn't matter whether you're married, doesn't matter whether there's a spouse, it can be two brothers, it can be two friends, doesn't matter. If you have a jointly held asset, whether that be a bank account or a property, it automatically passes to the surviving joint owner under the rule of survivorship. And that leaves a surviving person, spouse, friend, whatever they are, they will own 100% of the jointly held asset. And then a couple of problems then, because you want it to go to your beneficiaries, normally your children, when the spouse is gone, but now the spouse is still alive and they own 100%. So if they then go into a care home, 100% of the property and the money can be taken to pay for the care fees. And it's probably about £1,500 a week on average these days for a care home in Wales and England. So even if you've got a £500,000 estate, that could be eaten into at £1,500 a week to pay for the care fees. Also, if one of you was to pass away and then the other one married somebody else, then it can go sideways to that new spouse and the children could potentially be disinherited. That's called sideways disinheritance. And we see that a lot. We say, oh yeah, my mum died and my dad's still alive now and he married somebody else the other day. And now because he's married somebody else, he hasn't redone his will. And if he dies, it's all going to go to her. And the problem is I'm going to end up with nothing. And we say, right, so that's a bit of a problem because it's up to your dad now to change his will. But from what you're telling me, he doesn't want to change his will. He does, but he's going to do it tomorrow. And as we know, tomorrow never comes, yeah? So tenants in common protects against both of them scenarios. So I always like to use the example of me and Sarah. We got, like 4 properties in total, and all of them are owned 50% each. So that way, if I was to pass away, my 50% goes into my trust. I have a trust in the will called a discretionary trust. So 50% of all of them properties will go into my discretionary trust in the will, which can go on for 125 years after my death. And that way then, if Sarah goes into a care home, if she marries somebody else, if she goes bankrupt, if she gets into financial difficulty, none of them things matter to my trust because that's guaranteed to go to my children. And also I've changed the age of inheritance as well to 25. So they'll be a lot more mature to receive such a large amount of money. But if I left the assets jointly owned, if I died or Sarah died, one of us is going to end up with 100%, and it's not guaranteed it'll go to the children. And as Christians, that wouldn't be fulfilling our stewardship, because the Bible says a good person leaves an inheritance, not just to his children, but his children's children. And by leaving assets as jointly owned, we're leaving it up to somebody else. We're not taking that responsibility, you see. So tenancy common, very popular. If you have a jointly owned property, you split it into 50-50. So I don't think I actually explained what that meant. Tenancy common means that you own 50% each. So you own a separate 50%, as opposed to 100% as a single unit. You own 50% each. So when we write your will with a discretionary trust in it, it can receive the 50% of the properties and also 50% of the money. And then whichever one of you dies, that 50% is protected and it's going to your beneficiaries regardless of what happens with the surviving joint owner. Amazing, okay. And also then, I think we've got trust in the will. Yeah. Okay, so now we got trust in the will, yes. So the power of a discretionary trust in the will. So a lot of people know about a will. And they say, oh, I just want a will. And we say, oh, what about a will trust or a trust will? They're like, oh, I've never heard of one of them. Is it like a will? Well, it is a will, but it's called a will trust. It is a trust inside the will, yeah? So do you want to explain more about that?
Yeah, so the will is written basically to state everything I own when I pass away will come into my trust, which is written into the will. You appoint trustees, which are the people that would oversee your trust assets. Obviously, executives are appointed in the will as well. Then you would set out then exactly what you would like to happen to everything. But it's a discretionary trust, so the trustees are always in control. So I always say you have to trust your trustees because they are going to be the decision makers after your days. So again, usually spouse and children are appointed as trustees. And then you would set out then basically your wishes as to what you want to happen to everything then as a memorandum to the trustees. So it's very powerful. It can last for up to 125 years. So we could be protecting, multi-generations. And it's designed to set up then and protect the bloodline. So it wouldn't be lost then to any third parties. And if there's any divorce going on with any of the children, if the children are on any kind of means tested benefits or bankruptcy, it just protects them. It's only going to them and it'll go to them when they're right and ready to receive it.
Yeah, absolutely. So it's basically, some people call it a bloodline trust. It's designed to stay in the bloodline up to 125 years after your death, and it can't go sideways to any different third parties. Yeah. So we had a man recently, he came to us, he was separated from his wife. They had a young family, they were separated, they were going through a divorce. During the separation, his dad passed away with $500,000, and he had 2 sons, and in the will, he'd nominated his 2 sons as the beneficiaries. So that one that I spoke to there received £250,000. When the divorce went through, he had to share it with his ex-wife. So it ended up costing him £125,000. Now, if his dad had had a trust in the will, he still would have died and left it to his 2 sons, but he would have nominated them as trustees of the trust and beneficiaries of the trust, but it wouldn't have formed part of their estate.
Yeah,
it still belongs to the dad,
the
trust of the dad, up to 125 years.
Yeah, exactly. And it could have just been held until after the
divorce had gone through,
and then
he could have taken it after the divorce, and it would have literally saved him £125,000 of his dad's inheritance. And then another man that I spoke to, this was even worse. He was bankrupt. He had a restaurant, and it went badly during COVID, so he had to declare bankruptcy. And as if that wasn't bad enough, his mum and dad then passed away within 6 months of each other. A bankruptcy takes about 12 months, so he's declared bankrupt for 12 months. During them 12 months, within 6 months of each other, his mum and his dad passed away, left him the inheritance in the will, but because he was bankrupt, he couldn't get the inheritance. It went into the bankruptcy. So not only did he lose his own inheritance for his own children, he lost his mum and dad's inheritance as well. It was a double whammy. Now, his mum and dad could never have predicted that was going to happen when they wrote that will. There's no way that they could have predicted, like 30 years later, their son was going to be going through bankruptcy, but they wouldn't have had to predict it, because if they put a trust in the will, if he wasn't going through bankruptcy, no problem. He can still take the money from the trust. But the fact that he was going through bankruptcy means he could have kept the inheritance and he could have taken it out of the trust as a loan, and it's got nothing to do with the bankruptcy because it belongs to the mum and dad's trust up to 125 years. So you never think your children are going to be going through divorces, bankruptcy, financial difficulty. You never think they're going to be on means tested benefits. They may need some form of care themselves in the future.
Yeah, they could be vulnerable.
They could be vulnerable with some kind of addiction.
Yeah.
It could be like alcohol, drugs, gambling. It could be having an addiction.
Yeah.
You wouldn't want them to receive a lump sum because it could literally kill them. But if it's in the trust, they can have an allowance from the trust because it's a discretionary trust. So the trustees use their discretion, and they wouldn't give a vulnerable beneficiary a lump sum knowing that the mum and dad's wishes were for that not to happen. So that's the power in a trust, guys. We couldn't state, you know, I couldn't sleep at night if I didn't have that trust in the will, because I got 3 young children and I want to make sure that it stays with them when I go, because otherwise what's the point of me working hard and doing all that I'm doing if they're not even going to get it anyway? That just makes no sense at all. So yeah, it's a powerful document, and we couldn't recommend it enough.
Yeah.
Yes, okay, yeah, we covered all that, yeah.
Yeah, we covered that.
Interest, well, okay.
Yeah. Oh, sorry.
Interest in possession trust, but that's we can talk about all these. Yeah, sorry. Okay, so we're on to the inheritance tax basics. Yeah, so every person gets what's known as a nil rate band. So this is the tax-free allowance that every single person gets by default, and it's £325,000. So if you're a couple, you get 650. If you're a single person, you get 325,000. Yeah. Now there is something which is known as the residence nil rate band, and it's an extra allowance that you can claim. It does have to be claimed. It's not automatic, so it's got to be claimed during probate. And a lot of people don't know they can claim it. And the probate, it's not their job to tell you about it. You have to apply for it effectively. And some people don't claim it, and they pay unnecessary inheritance tax because it's just like a benefit. If I was entitled to PIP or something, I would have to claim that from the government. They're not just going to give it to me. I have to say, well, I'm entitled to this benefit, and here's my form to receive this benefit. And it's the same with the residence nil rate band. But it's an often overlooked thing where a lot of people don't know about it. But it's an extra £175,000 per person if you're leaving your main residence to your direct descendants.
Yeah.
You then get to claim an extra 325,000. So in mine and Sarah's case, we own this house. It's a main residence. We have direct descendants, which are our children. So our inheritance tax allowance is £1 million. We get £500,000 per person. So if we pass away with less than £1 million, there's no inheritance tax to pay when the second person dies. If it's more than £1 million, it's 40% on everything over 1 million. So it's not 40% of the million, it's 40% on everything over 1 million. Now, by the grace of God, we hope to die with more than 1 million. At the moment, we're 43 or 47. But by God's grace, we've got a long way to go, yeah? So we're hoping we'll pass away with more than 1 million. And then we'll start to do lifetime planning, where you move assets outside of your estate now, whilst you're still alive. And as long as you live for more than 7 years, they won't be subject to inheritance tax, you see?
Yeah, so obviously there are lifetime planning options, and we work in partnership with Countrywide Tax and Trust Corporation, and they would do any inheritance tax planning and lifetime planning. Trusts, you know, if you're over the inheritance tax threshold and you're ready to start gifting away assets or putting some strategies in place, then you can utilise our partner company for the lifetime planning as well, because they're extremely knowledgeable. They know their onions when it comes to gifting and what you can and can't do, and it works out the tax efficiency of any planning as well for you. So, you know, it's not a magic handbag, as I call it. You put your everything in there and make it disappear. But if you've got time ahead of you, the 7-year rule will apply, obviously, with gifting. If you've got time ahead of you, the sooner you can start lifetime planning solutions, the better.
Yeah, exactly. The reason Sarah mentioned the Magic Trust, we get a lot of people coming to us. They've watched TikTok videos and YouTube videos, and I can put everything in a trust and I can just make it disappear. Like, I set up the trust today and I wake up tomorrow and all of my estate has disappeared into this Magic Trust. And then when I die, there's no inheritance tax. And we're like, you know, the amount of misconceptions out there. So, you know, like Dave down the pub, we say, or John down the pub has told them something and they take it as gospel. And then they come to a company like us, and when we tell them, well, that's just not how it works according to the law. And they're like, yeah, but I've heard about it. I'm like, yeah, but you've heard wrong. You know, inheritance tax planning is amazing, and there's some great strategies that the government have put in place. But you've got to live for more than 7 years. There is another one that's only 2 years. But either way, it's not automatic. It's not put it in a trust and it all disappears. But we work in partnership with a company called CTT Group in Leamington Spa in Warwickshire, and they do our lifetime planning for us, because we specialise in the death planning with the trust in the will and the power of attorneys, And then if people are over the £1 million threshold, then we pass them over to Countrywide for stage 2, which is the lifetime planning. Because there's no good just leaving their estate the size it is, because we're guaranteeing 40% on everything over the million. But then they go over for stage 2 then with Countrywide, and they've got a team of about 5 people. They've got about 60 in total, but 5 specialists, solicitors, lawyers, barristers. I mean, they know everything there is to know about inheritance tax. So they will give you every strategy under the sun. They think outside the box as well. So they will tell you some strategies that you wouldn't have even thought of with just a normal solicitor or a normal person you think knows about inheritance tax. These go above and beyond. So we're blessed to have them because the advice they give is second to none.
Yeah.
We had a couple recently come into us. They had pensions of about 1.8 million, which are coming into the estate from April 2027. They had a 1.1 million main residence, a £700,000 second home, and savings as well. So their estate was like literally way over the inheritance tax threshold. And the problem is if you go over 2 million, you lose the residence nil rate band. It starts to taper down. For every £2 you're over, you lose £1 of the residence nil rate band. So once you hit 2.3 million, you pretty much lose the £350,000 residence nil rate band. So now they've got an estate of like 2.5 million, and they've only got 650,000 allowance. So it's even worse now for them. So they're going over then for that advice to try and reduce the assets whilst they're still alive, do some kind of lifetime trust or gift trust. And then as long as they live for more than 7 years, it will reduce the estate by that amount, saving 40% of however much they can reduce it by, you know. So it's absolutely essential, and they were more than happy that they came to us. So yeah, amazing. And then business succession. So you don't want to talk more about this, and
Yeah. So when there's businesses, obviously it depends what kind of businesses you have, whether they're trading business, whether it's you're self-employed, whatever kind of business assets you have, you can give them instruction for the business assets within the will. There's a few options. You can absolutely gift your business shares in the business, or you could utilize business trusts. And there are obviously some business relief considerations there. If they're trading businesses, you want to pass down your bloodline, they continue to trade without you, then we do recommend a business trust then as well in the will. So we always speak to you, and it's always bespoke for what you own and how you own it. So there are ways of protecting business as well, of making a plan for the businesses.
Yeah, we had a lady, I think a couple of days ago, they've got one son who's 15. She's doing she's into property, and she follows a property guru. So she's doing like lease option agreement, what's the SA one? Service accommodation, things like that. Yeah. So she had like 3 properties in her name that she wants to leave in a limited company. So she wants a business trust now to pass them assets on to her son to make sure that they stay with him when she's gone, and he can take over the property and carry on doing the properties. So a business trust in the will, depending on the type of business, can be absolutely essential. And there's things that you could do with inheritance tax then, as long as they maintain the shares for more than 2 years after you pass away. So yes, you can actually protect your business as well, basically. Foreign assets. Yeah. Okay, this is a good one. Yeah, do you want to talk about it?
Yeah. So basically, again, it's always assessed on what you own and how you own it. If you've got foreign assets, so if you've got property or other assets abroad, we usually would recommend you get the will done in the foreign land. Main reason being the laws are so different across the world, and it's always better to have a separate foreign will for the foreign assets. And we would then put the foreign asset clause then within the will, just to really to separate the assets, to say that this is going to take effect in my UK assets. Please see my will in France, for example, or Jamaica, or wherever it is. So you're just separating the foreign assets to make sure they don't contradict and cancel each other out as well, to have that separation. So yeah, we would always add a foreign property clause there if they are foreign assets as well.
Yes, we put the foreign asset clause in the UK will, which says these are my UK assets to be dealt with under UK law. And then the foreign asset, if you have a will in that country, is to be dealt with under that law, and they don't contradict or overlap and end up revoking another.
Yeah.
So it's very absolutely essential. Whenever we write a will, when people have got foreign assets, we absolutely have to put that foreign asset clause in there. They do count towards inheritance tax if you're domiciled in the UK. So we had a lady recently, she had a property in Germany. She had 1/3 ownership of a property in Germany, which equated to about 300,000. That same couple I was telling you about, they got the massive estate. So she said, oh, does that count towards my UK inheritance tax? And I said, yes, because you're domiciled in the UK. You're not a UK citizen, you're a German citizen, because you didn't, you know, she didn't want to be a UK citizen for whatever reason, but she's still domiciled in the UK. So that 300,000 does still count towards the UK inheritance tax. But at least with a foreign asset clause, one isn't going to revoke the other. And then as part of the inheritance tax advice now with our partner company, they're going to take into account that asset there and see what they can do with, if there's anything they can do with that as well, you know? Yes, amazing. So yeah, the emotional cost of delay. Yeah, so there is two costs. There's a cost of doing it, and there's a cost of not doing it. And the cost of not doing it far outweighs the cost of doing it. For a lot of people, they count the cost of doing it, and they go, oh, you know, it's going to be expensive, or it's going to be this, but they're not counting the cost of not doing it. For example, a power of attorney costs, let's say, £1,200 for 4 power of attorneys. But if you don't do it, it could cost £8,000 for the court of protection and frozen assets for up to 2 years. And a court official being on your documents, making decisions over your own spouse and children. So the cost of not doing it far outweighs the cost of doing it. So that's what we try and explain to people. You've got to act, because if you don't act, there is a cost. It's a hidden cost. It's the cost of not doing it. But hopefully today, with some of the stuff that we shared, it's not so hidden anymore, and you can weigh up the cost of not doing it and think, I'd rather just do it. Yeah. So families often delay difficult conversations. It's a default option. Oh yeah, I'll put it off. I'll do it tomorrow. We had a man the other day. He came to us in October, I think, 25, but he procrastinated until about January 26th. I spoke to him in January this year, and I sort of taken the mick out of him. I said, you made the inquiry in October, and you're coming back to us now in January. I said, what happened? He said, yeah, you wouldn't believe. When I came to in October, I was absolutely fine. I just knew that I had to write a will. The other day, I got diagnosed with skin cancer. And the problem is, I've got a mortgage, which is in my name, and I got no life insurance. And now I can't get life insurance. And if I die, my wife can't afford the mortgage because she's a housewife and she looks after the children. So what am I going to do? I said, there's nothing you can do. I can't get you life insurance. You've just been diagnosed with skin cancer. If you pass away, your wife is going to be left with that mortgage, and there's absolutely nothing you can do about it now. I says, you should have acted on it when you came to us in October. Obviously, that was God prompting you to get it done in October. Now we're in January, and I literally can't help you. And that was a hard conversation to have, to tell someone, I can't help you because you procrastinated on making a decision that you knew in your heart that you should have made. So that's, you know, we can't stress how important these documents are, guys, yeah? The cost of inaction can be enormous. Estate planning is an act of stewardship and love and responsibility, as Gbenga said, and protection creates peace of mind. We can vouch for that.
Yeah.
We don't struggle with peace of mind at all, because we practice what we preach. All of these documents that we're telling you about, we've done ourselves, and it's absolutely great when you've done it.
Yeah, and I think the weight you have, a lot of people can procrastinate and they put it off, thinking, oh, I may sell this, or I may do that, or I may move house, or I may. No, you write your will for today and your situation for today. If your circumstances change, you update the will. It's always for today, and today is the best day to do it, because you just don't know.
Exactly.
Yeah.
Exactly. And we see so many people come into us, oh, my spouse has lost capacity, they just frozen the bank account, I didn't do power of attorneys, what do I do now? And we say, well, you've only got one option now, the court of protection, good luck. We wish you well, but we can't help you with it, you know? So yes, yeah, amazing. So the next slide then. This is the final bit then, guys. So this is key takeaways. So have an up-to-date will, or a will if you haven't got a will, obviously. Put power of attorneys in place, life insurance in trust, protect the family home and any other properties you've got, and plan for inheritance tax early, because there's only a certain amount you can move outside of your estate every 7 years. It's not a magic amount, it's 650,000. It's the nil rate band times a couple. So you could only move 650,000 out every 7 years without any capital gains tax or anything like that. So planning early is absolutely essential. So that's the key takeaway. So yeah, questions and answers then, guys.
Wow. Thank you so much. That was brilliant. And I think you covered a lot of grounds there. What a good news you have shared. Yes, well done to both of you, Sarah and Chris. I know that while you were speaking, some questions were coming in, and I'm sure could be a bit of you having to either repeat what you have said or make further clarification on those points, and so that people can understand the technicalities and the, if you like, the reason behind the point as well. That you're going to be making in response to their questions, because it's very important that as you want to put something in place to have the peace of mind, you must actually have the full grasp of what you're doing, the understanding that this is the reason why I'm doing what I'm doing. And I know that you do personal face-to-face tailor-made, bespoke advice depending on people's circumstances and families. And I know we have discussed something like that, and people who really want to then take further steps or care to know more or to take some actions can also find opportunity and have access to our professionals or to you. Yeah. So yes, we have few questions. Well done. So very well for what you've done. Done great jobs. There are a few questions here from people who are joining us from Facebook, YouTube, and LinkedIn. We have people joining from the US, Dr. Adewumi from the US, and virtually all the people I have here joining that I know their names. They're joining from the UK, and some maybe joining from Nigeria as well, or Africa. Yes, we have Timmy Tayo in the house. Yes, he's joining us as well. Darish joining us. Yes, a lot of people joining us that I can see their name, okay, to put their names and the city they're joining from. Well, again, if you're just joining, this is our professionals, our experts in this field. Chris and Sarah, they've been able to do their presentation, telling us, teaching us rather what we need to know, and then we're learning as they are presenting. And of course, you are free to do, if you have missed any part of this presentation, feel free to always watch the replay. It's always going to be there on Facebook, on YouTube, and also on LinkedIn. So feel free to help yourself to watch it again and then make notes if you care to. And that will really help you, because whatever it is you're learning today, it's not just for you to hear and forget about it. It's for you to take action. The intention is for you to take action, and I hope you'll be able to do that before it's too late. All right. So let me just push to you one or two questions here. I think you have this one. Can you see it on the?
Yes. Yeah. Is the life insurance interest for beneficiaries who are underage? Yeah.
Yes.
Yes. So yeah, absolutely. Yes. It's whoever the life insurance policy was there to cover. Who will be taking that policy out to protect? So is it the spouses, is it the children? So it's not just children underage. It could be for whoever you want to benefit from that life insurance policy.
Yeah. So I got a policy for 500,000. Sarah's 350,000 beneficiary, and my 3 children get 50,000 each. So if anything happens to me before the age of 67, I think it is, 500,000 paid out. Sarah's beneficiary for 350. I think that's like 70%, and they're like 10% each, which is 50,000. So that's and that's how I set it up. But I could have done it all for the children if I wanted to, but Sarah's got the mortgages to pay, so that would be a bit harsh, But I could take out more cover, so it depends.
Yes, definitely. Thank you for that. What life insurance will do to ensure that you can provide you can insure your life for your dependents, and your dependents are your beneficiary. They could be children, they could be underage people, or they could be even your parents who are elderly in case you pass, and if they are depending on you, the insurance can go that way as well. So thank you for that. So the next question is, will you put a will in a trust? what is the difference between revocable and irrevocable
Irrevocable,
trust?
yes.
Yeah.
Okay, so you can definitely put a will in a trust. It's called a trust will or a will trust. Absolutely, yes. We've got a will trust ourselves. It's not just a will, it's a will trust.
The trust is written
into the will, so it's a will with a trust in it.
When you pass away.
Yes.
Yeah.
Now, what's the difference between irrevocable and revocable?
Irrevocable trust. So basically, it's whether you can change it or not. So once you settle that, like trusts in the will, they're irrevocable because obviously you can't change someone's will and wishes after they passed away. But some lifetime trust could be revocable. That's the difference.
So that means you can still change that.
Make changes to it or not. Yeah.
Yes, that's the difference between irrevocable and revocable, whether you can change it or not. Yes, so that's personal preference.
Yeah. Let's be clear again on that before you move on, so that when you're talking about will and trust, I understand that on the trust, except it's different. Trust has there are different type of trust. Yeah. Some are discretionary, where you can, amend it at will, and then there are some that are absolute trust that you can change it. It's absolute. That's my knowledge. But when you then have trust in the will, or will in a trust, and the will can't be revoked, or if it's not revocable, but what type of trust are you likely going to have there? Would it be that of absolute or discretionary? Just to make it clear.
Absolutely, yeah. So the will trust that we do are discretionary trusts. So discretionary is a type of trust. You can also have like a bare trust as well. There's different types of trusts. Yeah, discretionary is, we feel, the most powerful one because the trustees have discretion. Now it can be discretionary will trust, which kicks in when you die, or it can be a discretionary lifetime trust, which kicks in whilst you're still alive. And that would be to make sure assets are outside of your estate in the trust. You live for more than 7 years, and then they're outside of your estate. But you might not want that. You might not want that to be changed. So you put it in a trust and it can't be changed. Or you might say, well, I put it in now, but I want to change it just in case I need to.
Yeah.
So that's the difference, basically.
Yeah. Wow. Thank you so much for that. Yes. Moving on. This is. I think we were talking about the residence. Yes.
Yeah.
So yes, Dr. Adeomi is writing this. I think it's writing from the US, and he said that near residence rate or tax equivalent in the US.
Okay, I'm not 100% sure on the US. Sorry.
Yeah, we're not familiar with that, but just looking on ChatGPT now, actually. USA, United States. Yes, USAIHT. Yeah, we don't cover America.
Yeah, that's all right. That's all right. Because because I advised you. Yeah.
40% it is at US. Very high for most Americans never pay federal or state tax. So it seems that they have a much higher ratio, like 30 million, I think it's saying there. So you wouldn't really have to worry too much.
I would get some advice.
Get some advice.
Yeah, exactly. So I was going to ask you to don't bother too much about that, because at the end of the day, you advise within Wales and England, within the law in Wales and England. So, and that's understandable. Thank you so much for that. Yes, there's another question, very important on this for you here. Yes, also from US. Dr. Adeomi writing, he said, business trust in the will. Does the will allow your children or beneficiaries to take over the business, or is it the memorandum of the business that determines succession?
So you can give instructions for in the will. As I said, it would either be, if it's going to trust, you would appoint trustees then who would be responsible for your shares in that business. So while it depends what kind of setup, if it's a limited company, another director may need to be appointed in replacement of you passing. So you can set out clear instructions and appoint trustees who you feel are best placed then to manage that business side of things. So they may not necessarily be the same people. You may have business partners or other people in the business that are better to look after the business as trustees rather than the family who are inheriting the property, for example, and the other inheritance. So it's down to the setting up of the trust and putting the instructions in that trust.
Yeah, so your children may not be good trustees because they may not understand the business, but you want them to be beneficiaries because you've worked hard to secure the shares and pass them on to your children as the beneficiaries. So they'll get the business profit, and they are the beneficiaries. But the business partner might carry on running the business to get the profit to leave to the children. Because if you put the children on as trustees and they make bad decisions, it may not make as much profit, isn't it? So it totally depends on the business and whether the children know anything about the business. You don't automatically put your children on as the trustees. Yes, you put them on as beneficiaries, obviously, but trustee is a different role,
Yeah, I think there'll be more. It will be important to know more about the structure and the nature of the business, because again, if it is a sole business and you are the only director, then some things can work. But if you have a limited company or partnership business that you have other shareholders in it, then the structure will be different. You may still be benefiting from it while you are a shareholder, and that benefit can pass on to your beneficiary. But if it is not that way, then I mean, what I'm trying to say here is that first and foremost, depending on the nature and the structure of the business, and then of course see how your children can benefit, and of course if they have to take over as well, depending on the nature and the structure of the business.
Yeah, so it depends on the structure of the business. We can give you bespoke advice depending on the structure of the business. Yes.
Yeah. Thank you. So yes, moving on. This is another question here. If you have a limited liability company, do you transfer the shares into the business trust?
You can do, or you can gift it to spouse. So you might want to just gift it to your spouse. There's no protection in that, obviously. So if it's worth a value, you would normally want to put the shares into the business trust, guaranteeing that for your children or your beneficiaries, and your spouse carries on with their shares in their own name and does whatever they want with their shares. But ultimately, if they marry somebody else, go into care, go bankrupt, then shares are guaranteed to go to your children, then you see.
Yeah, that's very clear. Thank you so much. Yes, this question coming from Lessons. It said, what happens if someone uses mental capacity without having an LPA in place? I think you emphasize on that, but please, you put clarity in place as well.
You're basically in the hands of the government for all intents and purposes. The hospital would make your decisions, they would make your care and welfare decisions, could be where you're cared for, how you're cared for. It's not necessarily the next of kin anymore. Next of kin is not recognised. So you're really in the hands now of the government in terms of your treatment and care. And as we said earlier, with the finances, your bank accounts could be frozen, and your family can't have access to do any banking or
even pay for your own care.
Even pay for your own care in some cases.
To help you, your own money to help you can be frozen from the people who love you and want to look after you with the money that you've built up to look after you. They're frozen out of it.
Again, the government would take over because they would just freeze your accounts and they would expect that care bill to be paid then at the end.
Well, not a good position.
It's a case of being exposed and then being too vulnerable while you are alive, vulnerable while you die.
Yes.
So I think there are other questions, but I'd like to quickly ask question on will. Okay, if you can, you say what happens legally when someone passes away without a will? I know you were talking about the LPA, A there, but what happens when someone passes away without a will legally?
So legally, obviously, they say it would be frozen, and without a will, you're next in line, or you're under intestacy law, whoever deemed to be the next beneficiary would need to be, if not already putting their hand up and saying, I'm your next of kin, they would arguably have to be traced, because it may not be an obvious, if you haven't got children and a spouse, who is your next of kin? So the family tree is looked at to find the nearest blood relative alive at the time, whoever that may be. So they would keep searching until they found a living blood relative, essentially.
Yeah, so a good way to look at it is, if you don't write your own will, the government effectively write your will for you. So you do have a will, even if you don't have a will, because the government will. You have a government will, and nobody wants a government will.
So the government will be the executor of your will.
Yeah, they will pretty much write
you know,
your will
whether
for
you
you.
write one or not. I know. Yes.
Yeah. So you have got one.
yeah.
It's not the one you want, though.
Yeah. So, so at what stage, therefore, can or should a person seriously consider creating a will? At what stage?
Any age. Any age. I mean,
if you've got children, as soon as you've got children, it's essential for appointing guardian. So as soon as maybe you buy a house or you have children, that's basically when you should start writing the will. And as I said, you do it for your position today, and then you just review it every few years to see, oh, that needs changing. Oh, I bought that. Oh, I want to. Do you know what I mean? It moves with you throughout your life then, to keep it updated. And it's not just for wealthy people, no, because you've got wishes. It could be, it could be things like funeral wishes, or any kind of, it could be, I want my jewelry to go to my sister. Do you know what I mean? Anything is, whatever you have it's important to you. So what would you want to happen to it?
Yeah,
and also,
go ahead.
Go on,
Go ahead, Chris. Yeah.
I was going to say, I heard on the Martin Lewis show a couple of years ago, it always stuck by me. Someone said, oh, if I'm not wealthy, so that means I don't need a will. And one of the solicitors said, what happens if you win the lottery on Saturday and die from the shock of it?
Yeah.
All of a sudden now you've got a multi-million-pound estate and you've got no will. And they were like, oh, yeah, I never thought of that one. So even if you're not wealthy, you win the lottery, you might die from the shock, and then you need a will.
Well, I'm not sure anybody would die of the shock like that. You better wake up. Anyway, I get the logic behind that. Yeah. So yeah, and then will is prone to review from time to time, isn't it? You can update it. You can always. So how often do you think one should review one's will?
I would say every couple of years,
every 2 years.
Just whenever there's a change of circumstance.
Okay, that's good.
If anyone moves house, you move house, if you acquire more assets, or if you want to gift change, just change the gifting, or
you have a business, you start a business.
It just moves with you throughout your lifetime.
All right, thank you. So you have a question here on the screen for you. When you're talking about estate planning, is it only for wealthy people? Because when you hear about estate planning, it's only those who have estate that have planned. So what is estate in this sense? What is estate planning? Is it only for the wealthy people, or should everybody, every family, also be consider this?
Yeah. So we had a couple coming to us the other day. They were renting a property. They didn't have a lot of money. They didn't have any assets, but they had young children. So it's essential for them to do a will, because if they pass away, the children potentially go into care for up to 2 years. So they didn't have any assets as such, but estate planning was still for them, because a will is part of estate planning, and that was probably the most important document they'd ever do. And also, if they become wealthy through either the lottery, or they have an inheritance, at least they then got a will in place as well, isn't it? So it's for everyone.
Yeah. Thank you. I think there's a question from Facebook as well. You can say if your spouse has a vehicle on finance which is not paid off yet and passes on, I think we better wake him up. But as a life insurance in place, what happens to ownership and remaining finance?
Okay, so obviously if there's finance and that finance needs repaying, but there is life insurance payout to settle that finance, maybe I'm thinking, can the car be kept here? That's what we're trying to find out. So ultimately, yes, the car could be kept by the beneficiaries it would depend then either who that car's been put to in the will, or otherwise it would fall under the residue, so whoever the residue beneficiaries are in the will. But if it depends on the finance company. If they want the car back, they take the car back, but there need to be some money there to pay it off.
But either way, it's a debt.
It's a debt.
It doesn't write off the debt if somebody dies. That's part of the debts which are to be paid first before the beneficiaries get paid. So that car on finance is being paid off either by the life insurance or by the estate.
Or it gets taken back.
Or it gets taken back.
Yeah.
Because it's not just being written off because the person died, which is a lot of people think. Oh, they had a loan and they had a car on finance and now they died, it's been written off. That's not how it works. It comes out of the estate.
Okay, so with the death, or what type of death die with the dead?
Yeah, the death don't die with you. Yes, exactly right. Yes. Yeah. What a really important point on that one is, let's say now the person was still alive and they lost capacity. What would then happen to the car on finance? That's where you need a power of attorney, because the financial agreement was between the person and the finance company. And if they lost capacity, they can't manage that agreement anymore. So then it could be frozen because it's now an agreement which is null and void because the person's lost capacity. So if you want to keep the car, if Sarah had a car on finance and I was driving it and she lost capacity, I can't have them taking that car back because I needed to take the children to school. But if I don't have a power of attorney, they're going to come and take that car off the drive and say, agreement over, we're taking the car.
I think that
it happened to Derek, Kate Garraway, her husband Derek. A well-documented story in April 2020. A famous presenter on GMTV, Kate Garraway, or Good Morning Britain, sorry. Her husband Derek apparently had a car on finance in his name. He lost capacity and they took the car back because she didn't have a power of attorney.
Wow.
Yeah, crazy.
Yes, that's very true. And then just checking if we have any other question. So I think people are just saying, that's so well done, everyone. So now, Chris, and so if there's anything, if there's going to be any message from your side as a professional, and then of course in relation to what we are talking about now, and with your experience of people receptive to such of your services, what would that message be? If there's a message to share among people about their disposition or understanding to estate planning, and of course, how people are reacting or responding to it or not. What would be your message to people?
I think the message would be act now before it's too late. Because when it's too late, it is too late. That man I told you about with skin cancer, having that conversation with him, knowing that he was leaving a mortgage for his wife that she couldn't pay, and he didn't take the responsibility of taking life insurance out to cover that mortgage, and now he's had skin cancer and he can't get life insurance. I mean, that's, as a man, he felt he'd let his wife down, he'd let his children down. And on top of all that, he's worrying about the treatment that he's now having. Is he going to survive? Is he going to die? And on top of all that, he's worrying about, if I die, my wife's left with a mortgage. And all that could have been solved with one simple conversation about putting life insurance in place and doing the will at the same time and making sure that his wife is mortgage free and can live without the mortgage and bring the children up. So act now before it's too late would be the overriding advice.
Yeah. Yes, and very important. Well, with what you said, a follow up to that is that nobody knows when it's too late until when it's late, and it could be late even the next minute. Because I always tell people, when it comes to protection and protection, the first thing I say is that you've worked so hard, you're successful, whatever things you are doing. You're successful, but you need to protect your success. And that's what you're telling us tonight. You need to protect your success. How do you do that to ensure that success don't end with you while you're gone? You need to pass it on. The other thing is, whatever it is, as an individual, once you've passed on, you would either leave two things behind, one of two things behind. See that debt, or will. You will either leave those two. You leave will or debt. And debt is when you're struggling with all this, no master power of attorney, no proper planning, coming for your mortgage or for the property. Your car is there, they are coming for it. So it's debt left there and they're coming for it. But when you leave a will, and I can tell you from your experience as well, even though it doesn't matter how much of the car finance, put it that way, as a debt, as a form of debt, you put in your will. Will is where you put a lot of valuables, a lot of successes, a lot of achievements, and people will give you, your flower for that, So it's very important to know that you got to plan and you got to do it immediately. And it's better to do it immediately and then get it updated from time to time than to leave it until such a time that you think, oh, when I get to this stage or when this happens, you will do. There's some things that once it's happened, you can't get it again. It's like we explained, you can never get it once it's happened, but you can get it before it happens, and then you benefit from it when it then happens, when you needed to make claims or things like that. It's just as insurance, And it's very important. Now, you've been provoking discussion we've had from both of you today, and I'm so grateful. And I've learned a lot, and I believe people have learned as well, and a lot of people are participating, passing comments and asking questions, not to be sure that they can learn more and they can be. So will you tell us quickly, I know that if people want to get in touch or know more, yes, they can reach out to us. We will then pass them to you as much as we can. But I'm not sure if you have your contact details as well on your slides. If you don't, then we can always, they can always get in touch with us. We'll pass them to you. But if you do have it, please feel free to share your contact details as well.
Yes, contact details. Let me share screen or. Well, yes, I mean, if anyone sort of wants to get in contact, I could give them to you, Gbenga. We should have put them on the end of the slide. I didn't think of that one, actually.
I don't.
We've got everything else apart from that. But, I mean, yes. Can we put, there we are. Customer service. Oh, there's someone's put them in there, yeah. So customer service.
There we are.
Yes, there we are. Customer service is at trinitylifelimitted.co.uk.
Okay, well done.
And there's our phone number there, 01792 983 327. And our website is trinitylifelimitted.co.uk. And you've got to spell the word limited, not LTD, spell it out limited.
Yeah. Lovely. Well done. Yes.
In some circumstances as well, people might qualify for a free will. We do what's known as the Christian Legacy Program. So in certain circumstances, people might qualify for a free will. So when you come to us, we'll assess that, and if you qualify for the free will, you get the will for free. You might want to do the other stuff as well, but you get the will for free if that's all you want to do,
Okay, lovely. Thank you so much for yes, guys. Thank you for tuning in today, and I know that a major takeaway from this masterclass is that true wealth is not only about what you build during your lifetime, but also about how well you protect it for the people you love. So you can keep making your dependents and the people you love smile every now and then because of what you've done with your success. So proper planning through wills, trust and lasting power of attorney, and family protection strategies ensure that your wishes are honored, your loved ones are protected, and your legacy continues, with peace and also with clarity, and is so secured for future generations. So the greatest risk is not planning too early. It is waiting too late.
Yeah. Amen.
So don't let us leave it for too late. What an incredible, powerful session we have just had. It's been so wonderful. People are saying thank you to you, Chris and Sarah. Thank you. People are saying, thank you very much. So it's been very inspiring. So with an incredibly powerful and enlightening session this has been tonight, on behalf of the entire SkillsMindset Masterclass community, I would like to sincerely thank our special guest speakers, Chris and Sarah White, for sharing such profound wisdom, practical guidance, and invaluable insight with us today at this masterclass. We will always have access to bring you back if need be, on popular demand. If people are asking for some questions that we can answer, we would rather reschedule that you do the second edition. And please, that's just an invitation that you please be prepared. We don't know when, but it could be soon, because when people are coming in with inquiries that we thought, rather than answering many people at different times, why not attend to such a masterclass where you can answer all the people at the same time. So tonight's conversation has reminded us, that securing our future is not something we prioritize. It is something we must intentionally prepare, for today. And so people are still saying, thank you, Sarah, very informative, thank you, Sarah, and, Chris. So it's been very good. So thank you for helping us understanding that estate planning is not simply about document. It's also about protection, preservation, and reducing future burdens, and ensuring peace of mind for generations to come. So everyone who joined us tonight, and to those who will be watching the replay, we say thank you for your presence, engagement, and participation. We trust that this masterclass has not only informed you, but also inspired you to begin important conversation with your family, with yourself, with your business partners and associates, and take practical actions towards securing your tomorrow today. Remember, the decision you make today can either create confusion or create clarity to the people you love. We encourage you not to let tonight's knowledge end as an inspiration alone, but let it become, an implementation. Once again, thank you, guest speakers, for honoring the SkillsMindset Masterclass, for invitation and on this platform, especially on your first appearance with us. We truly appreciate your time, expertise, and contribution. And to our audience, stay connected, stay empowered, and stay intentionally, about building a secure future. If you have any question, comment, or inquiries about today and about SkillsMindset Masterclass, please visit our website at www.skillsmindsetmaster.com and leave us a message. One of our team members will reach out to you. We also encourage you to subscribe and follow us on all our various platforms so that you don't miss any of our episodes. I urge you to approach every moment with courage and optimism. Keep pursuing your dreams with knowledge and unwavering passion. Until next time, take care and stay focused. Goodbye for now.
The world is changing, and so does change. But the mind has the potential to capture the changing world and make every change count. At SkillsMindset, the leading global skills, strategy and corporate development company, we believe that the mind has the potential of transforming the man from obscurity to prominence. It's the reason why we make skills our business. At SkillsMindset, we stand for change, for development and for success. We challenge, we inspire, and we lead. With SkillsMindset, your limit is just the beginning. Welcome to SkillsMindset. For more information about the great service we provide, please visit our website on www.skillsmindset.com or give us a call on our UK number on 07957 676 193. Better still, send us an email on info@skillsmindset.com. Skills Mindset, challenging limits, maximizing opportunities.